So the ATF's restriction on forced reset triggers was just struck down, and it was struck down using the Supreme Court's recent 6-3 decision in Cargill. Now, really quick before we jump in this video, I want to ask you guys for a favor. You all know that here on YouTube, YouTube loves to unsubscribe people. So one of the things I would ask you to do is just double check to make sure you're still subscribed, because a lot of people get unsubscribed. And then also, if you enjoyed this two-way content, if you want to support it for free, one of the best ways to do that is simply to subscribe or to share around. And then also, if you're interested, we have a newsletter available. We are reaching the benchmark of 5,000 subscribers on the newsletter. And once we do that, we're going to be running monthly giveaways over there. So again, if you're interested, check that out using the links down below. Now, as I mentioned in the intro, we're going to be talking about some major news, and this involves the battle between the ATF and rare breed triggers about all the restrictions on forced reset triggers and the ATF suddenly trying to regulate those triggers as actual machine guns. You may recall that earlier this year, we received some news that the lower court in this case issued a preliminary injunction, which essentially temporarily blocked the ATF's current attacks on forced reset triggers. But now the same judge, the great and powerful Judge Reed O'Connor, who's probably up for his sainthood now, probably the same as Judge Benitez. He's issued a ton of favorable Pro 2A decisions. He now has granted NAGR and then also rare breed trigger their motion for summary judgment. That means that Judge O'Connor has reached a final merits decision, striking down the ATF's restrictions on FRTs, essentially finding that that action by the ATF was in fact unlawful and was beyond their authority, that they overreached their authority, and under the text of the statute, the ATF could not do this. So back in July of 2021, the ATF sent out a cease and desist letter to rare breed triggers and then also a bunch of other companies that produce FRTs. Now, in that letter, the ATF claimed that in their eyes, the rare breed FRT 15, the forced reset trigger, meets the NFA and GCA's definition of a machine gun. Now, because of that, the ATF claimed that the triggers were essentially subject to registration, taxation, and possession restrictions like actual machine guns. Now, in response to that letter and the actions by the ATF, Rare Breed then filed multiple lawsuits, but most recently, Rare Breed then partnered with NAGR and they filed a lawsuit against the ATF in the Northern District of Texas. And the case was assigned and submitted to Judge Reed O'Connor. And essentially, he was assigned that case because he was already reviewing a bunch of cases that dealt with ATF overreach. Now, again, like I mentioned, there's a lot of other context going on with these lawsuits. While all this other lawsuit was going on down in the Northern District of Texas, there was another lawsuit that was going on in New York. Essentially, the federal government, the US government, filed a lawsuit against rare breed triggers in New York in the Eastern District of New York. Ultimately, on review, the federal district court there ruled in favor of the federal government and granted a request for a preliminary injunction. And that preliminary injunction against rare breed triggers and rare breed firearms essentially prevented them from engaging in any sales of various FRTs and then also other devices. Now, that decision in New York is important to reference because also in this recent decision by Judge O'Connor, he had to acknowledge what was going on in New York and had to carve out some exceptions to the ruling that he just issued. Now, originally on review, Judge O'Connor granted the plaintiffs the request for a preliminary injunction, but that was just simply a temporary form of relief. Judge O'Connor, in reaching that original decision, used the en banc panel's decision in the Fifth Circuit, essentially their ruling in the Cargill case, which struck down the ATF's interpretation of bump stocks as machine guns. Now, in response to the granting of that limited preliminary injunction, the ATF first sought a stay of that, and then the ATF had to simply proceed forward at the Fifth Circuit level on appeal, and there's an appeal going on right now with a preliminary injunction in question. But again, while all that was going on, because again, there's a lot going on all at once, this lawsuit was still proceeding forward in front of Judge O'Connor, but towards a final merits decision. Essentially, NAGR and rare breed triggers continued forward. They were seeking a motion for summary judgment, essentially to reach a final merits decision to end the case right here and now. But ultimately now we got news that Judge O'Connor again has sided with all of us and has struck down the entire ATF restrictions on FRTs, which is a huge win. This is a final merits decision, a motion for summary judgment in favor of the Pro 2A side, striking down this ATF overreach. Now, in reaching his decision, Judge O'Connor again relies heavily on the analysis in the Cargill case, and then also that recent Supreme Court 6-3 decision, finding that the single function of a trigger is not a single pull of the trigger, essentially going against what the ATF had been arguing this whole time about why they could regulate these triggers. Judge O'Connor stated in his decision that function and pull are not synonymous. The former is based on a mechanical perspective, whereas the latter is based on the shooter's perspective. He went on to state that applying the guidance from both Cargill decisions here, FRTs do not fire multiple rounds with a single function of the trigger and thus do not qualify as machine guns. So we all knew that the Cargill decision would in fact have important trickle-down impacts on all ATF cases, and now we're seeing that play out here with the FRTs. Now, that's not to say that this was not foreseen. We were all anticipating that this was going to happen, especially because Cargill was a case that came out of the Fifth Circuit. The Supreme Court upheld what the Fifth Circuit said. And here also, like I mentioned, Judge O'Connor relied heavily on the Fifth Circuit en banc panel's decision in Cargill. Now, in his decision, he states that there is no denying the tragic nature of the Las Vegas shooting that motivated the final rule. But no matter how terrible the circumstances, there is never a situation that justifies a court altering statutory text that was democratically enacted by those who are politically accountable. That responsibility belongs exclusively to Congress. The Constitution assigns such legislative choices to the appropriate elected officials, not life-tenured judges and unelected bureaucrats. Rather than respect this intentional feature of our democratic system, the defendants chose to advance a policy agenda wholly divorced from the NFA's statutory text. Thus, to allow defendants' unlawful action to stand would be to functionally rewrite the NFA. That is not how our democratic system functions. He then goes on to say that this potentially took the public's interest away, that it took the attention away from some of these bills, essentially saying that the ATF took upon themselves the power to legislate, which of course is wrong. Here, the ATF does not have the power as an agency to circumvent the legislative process, to chip away at this whole separation of powers, and to do whatever they want. They cannot concentrate all this power on their own, and here that's what Judge O'Connor is saying. He's saying that the ATF overreached, took the legislative power on their own by regulating FRTs. And based on that, he vacated the ATF's classification of FRTs as machine guns and declared that the ATF's determination that FRTs are machine guns is in fact unlawful. And as a result of that decision, he enjoined the ATF from enforcing the restrictions against the plaintiffs, the organizational plaintiffs, the companies, their members, NAGR and their members, and then also any downstream customers who maybe came in possession of these items. And he said that those types of injunctions are in place as long as they don't impact the ruling that we mentioned that happened in New York. Also critical to this decision was Judge O'Connor prevents the ATF from pursuing criminal proceedings or criminal enforcement against anyone, against any of these parties or anyone involved in this. And then he also ordered that the ATF must return all FRTs and all components and all items that they confiscated within 30 days of this decision. So that's a big deal. Again, the ATF had confiscated a bunch of these items. They went directly after Rare Breed and a bunch of other companies and a bunch of people because of these items. And here Judge O'Connor is saying, nope, all of that is washed out. And then also you have only 30 days to return all these items. So that's a huge loss for the ATF. I cannot overstate how big this decision was against the ATF. Now, Judge O'Connor then concluded his entire decision by stating that every year our country commemorates the revolution waged against a tyrannical executive. To safeguard against future tyranny, our founding documents designed a system that prevents undue concentrations of power in order to protect important rights and to ensure that a legislative consensus is reached before enacting laws on the most important issues in society. Such foresight is especially prudent in cases like this one. Indeed, while this case may seem focused on firearms, it represents so much more. It is emblematic of a devastating problem that increasingly rears its head in federal courts: rampant evasion of the democratic process. Few issues more accurately underscore this problem than the one present in this case. Our nation would do well to remember the very reasons and spirit that inspired our democratic system of governance in the first place. Now, you may be asking, where does this leave us now? So as of right now, this rule is vacating. The restrictions on FRTs is vacated. Again, there was that 30-day notice from Judge O'Connor in the order that they need to return those items within 30 days. Now, again, I would fully anticipate that the ATF is going to appeal very soon. They're probably going to seek a stay first from Judge O'Connor on this order. I would anticipate he denies it, and then they're going to go to the Fifth Circuit on an appeal. Also probably seek a stay from the Fifth Circuit, and we'll have to see what the 3-judge panel says about that. So the ATF is in a very hard spot, but I do not feel bad for them at all. This is a significant win. It's a solid win. And as we get more information, as things develop, I will let you guys know. So again, if you guys like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.